Good morning. It's 10 a.m. on Tuesday, September the 10th, 2024, and I'd like to call to order the board meeting for the Tennessee Board of Funeral Directors and Embalmers. As we begin the meeting, I would like to bring to your attention there is a sign-in sheet on the table by the door. And for anyone that would like to make comments about an agenda item, please indicate so by your name as you sign in. Public comments will be accepted near the end of our board meeting. Ms. Bohannon, would you please give the roll call, please?
Don Haynes.
Here.
Chris Lee.
Here.
Randy Nash.
Here.
Wendell Naylor.
Here.
Scotty Porsche. Pam Stevens.
Here.
Tim Willer.
Here.
Ms. President, we have a quorum.
Thank you, Ms. Bohannon. At this time, I will entertain a motion to adopt the agenda that's been presented to us.
So moved.
Second.
There's a motion by Mr. Lee, a second by Mr. Wheeler. Any discussion about the agenda? All in favor say aye.
Aye.
Any opposed? Motion carried. This time, your minutes were emailed to you previously for the August 13th meeting that we had. And if everybody's had an opportunity to review those minutes, I will entertain a motion.
So moved.
Second.
Have a first by Mr. Wheeler, a second by Mr. Lee. Any discussion about the minutes from the previous board meeting? All in favor say aye.
Aye.
Any opposed? Motion carried. Mr. Bryant, good morning, and again, thank you for sending our legal report. And if you would, at this time, share with us the following cases.
Good morning, board members. The first complaint is complaint number 2024-039111. Complainant, daughter of the decedent, stated their mother passed away on May 24th, 2024, and that they had gone to the funeral establishment and signed papers entitling her to receive the cremains. Complainant alleged that upon their arrival, respondent would not follow through with what they had promised her. Complainant stated that they were waiting on her siblings to make a determination as to next of kin, and complainant claimed respondent had communicated it would be 72 hours before the cremains were provided, but that it had ultimately become 7 days. Complainant stated that 6 weeks have now passed as of the date of filing the complaint, and they still cannot receive the cremains. Complainant claimed to be the executor of the decedent's will and claimed to have sent the proper paperwork stating she is supposed to receive the cremains. Complainant did not attach any of this paperwork to their complaint. Complainant stated, quote, "I've sent all the paperwork, and yet they still will not let me have my mom's ashes, and now it is going before a judge because my horrible sister had to be contacted to sign for next of kin." Legal spoke to respondent's counsel to get a better understanding of the situation. Respondent's legal counsel explained that at the beginning of their services, complainant had filled out documentation with the funeral establishment indicating that the cremains would go to her and implying that she was the sole next of kin candidate. However, it was soon discovered later that there were other siblings in addition to complainant. Upon bringing this discovery to complainant, complainant then stated that the intent was to spread the cremains 50-50 among her and another sibling, ultimately leaving one sibling out. After this, complainant presented information to the funeral establishment indicating she had POA authority, but all appropriate documentation regarding the POA had not been submitted. As a result, the funeral establishment referred the matter to probate court so that next of kin could be determined by a court of competent jurisdiction, and their legal counsel stated that their hands were tied due to competing claims of the decedent's cremains, and that a judge's determination was ultimately required. Based on the above, we would recommend closure.
Are there any questions for Mr. Bryant?
Motion to accept council's recommendation of closure.
I have a first by Mr. Lee, a second by Mr. Naylor. Any other discussion regarding this? All in favor say aye.
Aye.
Any opposed? Motion carried.
The next complaint is complaint number 2024-039361. This case was administratively opened following a routine inspection conducted on June 12, 2024. During the course of this routine inspection, the inspector observed the following. The manager for respondent establishment had a funeral director's license that expired on May 31st, 2024, and was not reinstated until June 2nd, 2024. The inspector found no evidence that the manager had acted in the capacity of a Tennessee funeral director or embalmer during this time, but the individual was still acting as the manager for respondent establishment during this time. Respondent stated they had attained all CE hours, but that when making a call to the State Funeral Directors Association office on May 31st, 2024, the day of the license expiration, the website was erroneously showing that the individual had obtained the necessary hours for their funeral director's license, but not for their embalmer's license. However, one of the individuals at the State Association office was not available to speak to at that time about the information it was showing. The individual spoke with the State Association employee the following Monday, June 23rd, 2024, and they stated it was an error that erroneously listed the embalmer CE had not been completed. The individual stated had they known this was an error, they would have paid the renewal fees on Friday, but because they wanted to follow up on the reported lack of embalmer CE, they did not do so until Monday. Based on the above, we would recommend a letter of warning.
Are there any questions for Mr. Bryant?
Motion to approve.
I have a motion by Mr. Haynes, a second by Mr. Nash. And are there any further discussion? Because I have something I'd like to point out. Sometimes it is confusing for funeral directors and embalmers to know the difference between the state association and the state board. And so in these notes, in legal, it says that this person went before the state association as opposed to the state board. I just want to make sure that the public is aware that when the licensing is something that they have to go through, that they do not go through the Tennessee Funeral Directors Association, that they do go through the board. Just a little something.
No, and I think that's an important distinction to make, that, you know, at the attorneys have similar continuing education requirements, and at the end of the day, whatever, you know, you may have other sites out there that say your hours are this or this, but whatever we have from the Board of Professional Responsibility, that is the gospel. And you roll the dice a little bit when you take from other sources, but.
I'm sure Mr. Batson would not like that responsibility, so I wanted to make that clear. Okay. So there's a motion by Mr. Haynes and a second by Mr. Nash. All in favor, say aye. Aye. Any opposed? Motion carried.
The next complaint is complaint number 2024-039361. This case was administratively opened following a routine inspection conducted on June 12, 2024. During the course of this inspection, the inspector observed the following. The manager for, I am so sorry, I'm reading number 2 again.
Okay.
Did not want to reopen that. Ignore everything I just said. The next complaint is complaint number 2024-039371. This case is administratively open following a routine inspection conducted on July 8th, 2024. During the course of this routine inspection, the inspector observed the following. Respondent establishment had failed to report its change of location after moving into a new place of business as of February 2024. Respondent replied stating that while the mailing address did change, the change was only to a different suite in the same building. For example, changing from Suite 110 in generic office building to Suite 100 in the same generic office building, but argued that the applicable rule only requires written notice to the board in the event of subsection B, change of location of a funeral establishment, or subsection E, change in the mailing address of any funeral director, embalmer, or apprentice. Respondent argues that the location did not change under subsection B because they are in the same building, just a different suite, and agrees that the mailing address changed from Suite 110 to Suite 100, but that subsection E only contemplates written notice for a funeral director, embalmer, or apprentice, not a funeral establishment. Respondent did not object to the necessary reinspection and accompanying fee to the change of suite location. Location, as contemplated in subsection B of the applicable rule, contemplates the physical location of the establishment. While they are in the same building and the location change is a minor one, respondent did not deny their previous location was Suite 110 and that their new location is Suite 100. So based on the above, we'd recommend a letter of warning.
Any questions for Mr. Bryant?
Just a little clarification. Is this going to be any kind of problems down the road, or is it something that you handled efficiently from being in the same building? I mean, it sounded like they were getting pretty precise on the law. I just wanted to make sure how legal and felt about it.
Yes. So I think their point was I understand their argument, but I think at the end of the day, the way the applicable rules are written, I don't know if it would be possible to have a smaller location change than moving from one suite to another. But it is a location change. That at the end of the day, if someone's coming through, someone's doing business, they're not going to suite 110 anymore. They're going to suite 100 now. And that under the law, location is interpreted that even in this more minute location change, it is still a location change.
Great.
So there doesn't need to be any cleanup of language with the law, do you feel?
I think with looking at it, I would not think so. I think it's clear, and I think one thing that adds to it is that with them not objecting to the anytime you change location, there's an inspection of the new location. Does it check all the boxes that need to be checked? The fact that they didn't object to the department coming out and conducting that inspection, which occurs when you change location, I think further indicates that point that I understand their argument, see where they're coming from, but I do think when reading those rules in totality together, I think what location means is evident.
Okay.
I guess our inspector went to suite 100 and nobody was there and he went down the hall. That the first finding we had that they had moved locations, I guess?
That was the first notice, to my understanding. I'm not sure specifically if he got there and realized it had changed, or if he maybe saw it on the outside marker, or anything to that degree. But from my understanding of this inspection was that he asked a question about it. They had moved back in February of this year, and he was out there in July.
Troy, I guess my concern is we're beginning to see more and more establishments in strip malls and places like that. And so that's why I was just wondering about the language with the law, if there's any type of cleanup needs to be done. I mean, I'm pretty simple. I understand when you move from one suite to another, you've changed your address. But, you know, I guess I'm looking down the road where we're seeing so much change in our industry. Is it something we need to look at, or do we feel comfortable through legal that we're okay?
Let me pull up the applicable rule just so I've got it in front of me. But I know in looking over this one, I spent a good amount of time with the rules, and
Mr. Bryant's not aware of this, but how all this came about, the backstory to it is, actually, the Bureau of Services auditor went out to do an audit on the pre-need cellar. And when he got there, they said, okay, we've moved, and so when you send the report out, and of course we email them, but we also put a mailing address on there, it said change the suite from 110 to 100. So the Bureau, we miss things, but we try to have good communication between the field people that are in the Bureau Services side and the funeral board side. So obviously, when the Bureau Services auditor made us aware in the office, hey, these people have moved, then that's what precipitated the field rep to go out and do the inspection. Mr. Bryant doesn't know that, and while he's looking at that, I thought it'd fill you in. That's what, I mean, like I say, they communicate back and forth. Sometimes we miss things, but we try to keep an eye out. And I remember a situation where years ago, one guy moved from Suite A to Suite B, and he argued he didn't have to do this, but he did it. He was in a building that only had 2 suites, and he moved from Suite A to Suite B, and that's been some years ago.
And so the applicable rule is 0660-01-.03. The title of that rule is changes. So section 1 just says, in addition to any other requirement of the board's rules or any statute pertaining to the profession of funeral directing or embalming, the following shall be reported in writing to the board by the licensee within 10 days of the effective date of the change. Essentially just, hey, if you're going to do kind of these bigger business changes, just give us a heads up. Subsection B is change of location of a funeral establishment. That is it. And then E is change in mailing address of any funeral director, embalmer, or apprentice. I agree with respondents saying that E does not require them to provide any notice, that because an establishment moved, not an individual. But I think change of location, it's a little bit of a, I'm going to get it backwards and embarrass myself, but the kind of square and rectangle relationship. Not all squares are rectangles, but rectangles are squares. So changing of location is going to change mailing address. And so I think B is more encompassing than E is because, like Mr. Gribble said, even in instances when you're moving from suite A to suite B or suite 110 to 100, I think subsection B is effectively broad enough that if a brick and mortar location is changing where it's at, they just need to write in within 10 days and give the state board office a heads up.
Thank you.
Yes, sir.
I have a question. Should it, instead of letter of warning, should it be letter of instruction?
I think that's fair if the board would prefer to go that route with it. I think, again, if we're looking at it from more of a misinterpretation standpoint, a letter of instruction may be more appropriate. And if that's what the board would prefer, then more than happy to.
That was my question.
Oh,
too.
sorry.
No, you're good. So that was my question. And I, at first I was reading through and I was curious why there wasn't a fine, but then the fact that they don't object to the reinspection or the fees with that, I think that I would make a motion to recommend a letter of instruction to this establishment instead of a letter of warning.
There's a motion on the floor to change the recommendation from letter of warning to letter of instruction. That motion was made by Mr. Nash. Do I hear?
Second.
Mr. Naylor, you're sitting right beside me. I heard that one first. Any other discussion? All in favor, say aye. Aye. Any opposed? Motion carried.
The next complaint is complaint number 2024-039381. This case was administratively opened following a routine inspection conducted on June 24th, 2024. During the course of this routine inspection, the inspector observed the following. The pre-need sales agent license of respondent's employee expired on January 23rd, 2023, and was not renewed until April 29th, 2024. During the unlicensed period, the employee had written 76 pre-need sales contracts. Respondent stated that the employee was unaware of the expiration and once it was brought to their attention, immediately renewed the pre-need sales agent registration. However, respondent stated that in the interim, the employee had written several pre-need contracts under just their insurance producer's license. Respondent stated the employee was not aware that the pre-need sales agent registration needed to be renewed and that the error was unnoticed until the inspection. Respondent stated that since joining the respondent establishment in 2021, this was the employee's first introduction to the funeral business and was unaware that renewal of the registration was required. The board recently heard the companion to this case at a previous board meeting. The respondent has multiple establishments where pre-need contracts are sold. At the previous case, the board heard and decided for the exact same violation in the amount of 77 pre-need contracts written at that location. The board assessed a $750 civil penalty. So based on that, for the sake of consistency, we'd recommend a $750 civil penalty authorized via consent order and a formal hearing if necessary.
Does anyone have any questions for Mr. Bryant?
Just one. When are they sent a notice that their license are to be renewed, just like we get for ours? Did they deny they had ever received the notice of renewal?
There was no information. I guess it's also a little tricky in that the respondent is the establishment. as opposed to the individual. So I guess they're kind of talking through what the individual told them. But no information mentioned about whether they had received notification of that. I know, too, there's a little bit of a, I guess, bad habit of if someone moves and don't update their address, and notice maybe sent to the old location, things of that nature. But they didn't address whether they had or had not received that notice, just that they were, that purportedly the employee was not aware that the pre-need registration also expired.
Was there a complaint opened against the sales agent themselves?
My understanding is that there is. That's on the pre-need side and
wouldn't be
falls
on
through
the-
burial services,
That's what I thought.
but there is a complaint open against the individual.
Did they have any other establishments that we're going to get more of this? If they have two, I'm just.
I will be honest, I do not know.
Okay.
There may be more, there may not be. I'm not entirely certain.
I make a motion to approve recommendation.
Motion on the floor by Mr. Nash, second.
Second.
Mr. Haynes, thank you. Any further discussion? All in favor, say aye. Aye. Any opposed? Motion carries.
Next complaint is complaint number 2024-039391. This case was administratively opened following a routine inspection conducted on July 8th, 2024. During the course of this routine inspection, the inspector observed the following. Respondent manager's funeral director's license expired on June 30th, 2024, and was not reinstated until July 2nd, 2024. During the inspection, the inspector found no evidence to indicate that the manager engaged in arrangement conferences, services, or embalming during the unlicensed period. However, the manager was still listed as manager during this unlicensed period. The manager replied on respondent's behalf, stating that they unknowingly allowed their funeral director and embalmer's license to expire on June 30th, 2024. The manager admitted that respondent establishment did not have a licensed manager for the period of June 30th, 2024 through July 2nd, 2024. Based on the above, we would recommend a $250 civil penalty, authorized via consent order, and a formal hearing if necessary.
Mr. Bryant, I have a question, and maybe I'm not reading it correctly, but what is the difference in complaint number 2 to complaint number 5, where one is given a letter of warning and one is given a civil penalty?
The difference there is the disciplinary history. The one on number 2, if I am remembering correct, let me triple check. Yes, has no disciplinary history. This one has some, I would say, a limited disciplinary history dating quite a bit back, but the last one they have, which was from 2013, so again, quite a while, but it is for the manager of the establishment license was invalid for 7 days while listed as the manager. So this is a violation they've had before, granted 11 years ago, but that is the distinction between number 2 and number 5.
Thank you. Any other questions?
I make a motion that we go with council's recommendation.
Motion by Mr. Wheeler, a second by Mr. Nash. Any other discussion? All in favor, say aye. Aye. Any opposed? Motion carried.
The next complaint is complaint number 2024-040801. This case was administratively opened following a routine inspection conducted on July 17th, 2024. During the course of this routine inspection, the inspector observed the following. Respondent manager's funeral director's license expired on June 30th, 2024, and was not reinstated until July 2nd, 2024. During the inspection, the inspector found no evidence to indicate that the manager engaged in arrangement conferences, services, or embalming during the unlicensed period. However, the manager was still listed as the manager during this unlicensed period. The manager replied on behalf of respondent establishment, stating that they had moved in August of 2023 and that the information for renewal was likely sent to the old location. The manager stated that when they realized on June 30th, 2024 that the license was expiring, they logged onto CORE to do the renewal. Respondent stated the CORE website did not allow them to log in, so they called the state office for assistance. Respondent stated they received a call a few days later from a state board staff member who the manager was very complimentary of, and were able to renew their license and update the address information. The manager stated that during this 3-day unlicensed period, they did not assist any families with arrangements or embalming. Based on the above, we would recommend a $250 civil penalty, authorized via consent order, and formal hearing if necessary.
It's like every complaint we've got, everybody's waiting till the last day to do it. And I think the core opens and allows you 45 days prior, if I'm not mistaken. I'm sorry,
60.
60 days. I knew,
Typically, if a license expires on the 30th of the month, then on the second day of the previous month, it'll open. And our office still continues to call all establishments. We don't call individuals. We don't have the ability,
and I
enough
guess,
ability to do that.
once again, if they had a notified office of their address change, we probably wouldn't have that problem now.
Isn't there also, there's an email that goes out too, is there not an email too? Generally, an email that you receive? Oh, I'm sorry. Is there just generally an email that goes out? I feel like there's an email.
Well, it depends on how the person has it checked. Sometimes they get an email, and sometimes Ms. Bohannon goes an extra step, and he'll email the establishments. When we see that there's a long list,
I feel like I get both for some reason. Maybe I don't. I don't know. I don't.
Yeah,
But
it depends, but we make every effort we can. Of course, this was an individual's license and not the establishment license that expired.
I just feel like this is like Mr. Lee said, this is something that, I don't know. I guess I'm just weird. This is how you make your living. This is your livelihood. This is your professional license. It's your responsibility to make sure that it's current, and especially it has to do with the establishment running as well. So I make a motion to recommend the penalty.
There's a motion on the floor by Mr. Nash,
Second.
second by Mr. Wheeler. Any other questions or discussion? All in favor, say aye.
Aye.
Any opposed? Motion pass.
The next complaint is complaint number 2024040801. This case was administratively opened following a routine inspection conducted on July 17th, 2024. During the course of this routine inspection, the inspector observed the following. Respondent manager's funeral director's license expired on April 30th, 2024, and was not renewed until June 10th, 2024. Respondent establishment had written 3 funeral contracts during the unlicensed period in which respondent did not have a licensed manager. Respondent replied stating that they were not aware of the lapse until the inspection. Respondent admitted to the unlicensed manager writing 3 funeral contracts during the unlicensed period, but upon being made aware of the lapse, the manager stopped meeting with families. Based on the above, we would recommend a $500 civil penalty, authorized via consent order, and a formal hearing if necessary.
Is one of the reasons why this went to $500 as opposed to $250 is because of the funeral contracts that were written?
Correct. We have, I guess, 2 things that separate this one from the several preceding it is that, one, we have a longer period of unlicensed activity where an individual not licensed or with an expired license was operating as the manager of the establishment, and 2, they had also conducted activity during that time with the 3 written contracts.
Thank you. Any other questions for Mr. Bryant?
I guess I go back to what Mr. Nash brought up earlier is it seems the only excuse we're getting is they're not aware of the lapse. And I just cannot figure out. I mean, I've been licensed, we won't go how many years, but I knew when I got my license right off the bat that I have to pay a renewal fee if I hope to keep my license. And I mean, it's just common sense. And I guess maybe I'm simple. I just don't like, I'm unaware that it lapsed. I'm sorry. I get my notices from the state board and we have several funeral director embalmers on staff. We always get them. They go into core and take care of it immediately as soon as we get our notices. So I just find that's a poor excuse. I see back in 2013, they got a $750 fine. I see they wrote 3 pre-need contracts, unlicensed at the period. And to me, each penalty deserves $250. I'm good with $750 as the penalty, just because they need to learn. And sometimes a heavier fine might keep him on his toes or her on her toes, that when your license come to be renewed, you need to take care of that. That is not this board or these people's job to make sure. I agree with Mr. Gribble. The state does not have time to get in touch with every licensed individual and tell them your license are about to expire. I mean, we do it for our car tags, we do it for our driver's license, you do it for hunting and fishing. Surely to God, this is your livelihood. You can keep up with your license that brings your income so that you can live and pay your bills. So my suggestion would, I think it ought to be a $750 civil penalty.
There's a motion on the floor by Mr. Wheeler to change the civil penalty recommendation of $500 to $750.
Second.
Second by Mr. Nash. Any other discussion? All in favor, say aye.
Aye.
Any opposed? Motion carried.
The next complaint is complaint number 2024-040851. This case was administratively opened following a routine inspection conducted on July 17th, 2024. During the course of this routine inspection, the inspector observed the following. Respondent is the individual from the previous complaint whose license had lapsed on April 30th, 2024, and it was not renewed until June 10th, 2024. Respondent wrote 3 at-need contracts during the period of unlicensing and was the manager of a funeral establishment during the unlicensed period. Respondent stated that they've been experiencing serious health issues for the past 18 months. Respondent stated that due to their health complications, their memory slipped and missed in-person classes for the continuing education that would have given them the 5 in-person hours they required. So based on the above, for the individual, the funeral director would recommend a letter of warning.
I'll make a motion to approve. Motion to approve.
There's a motion on the floor for approval of recommendation. Do I hear a second?
Second.
A second by Mr. Lee. Is there any discussion regarding this?
I'm not going to linger on this, but, so I'm assuming that when it's licensed, I'm sorry. We got warned by Miss Lisa, I'm scared to touch it. It expired on April 30th and then renewed June 10th, so it sounds like on April 30th, they hadn't even had any CEUs or anything. Is that what I'm reading out of it? Other than just renewing, because he said he never got the required CEUs?
I'm not entirely sure when they received those last in-person hours that they needed. I would say I think it is certainly possible to infer that from their response that they hadn't received them in time, and that contributed to the lateness of getting them. But I'm not 100% certain on that.
Did we have a motion? I apologize.
Okay, there is a motion on the floor by Mr. Nash, and you seconded, Mr. Lee. Any further questions or discussion? I will make this statement. This is a hard pill to swallow, but we all have our regulations and things that we need to do. There is a motion and a second. All in favor, say aye.
Aye.
Any opposed? Motion carried.
The next complaint is complaint number 2024-041311. This case was administratively opened following a routine inspection conducted on July 17th, 2024. During the course of this routine inspection, the inspector observed the following. A pre-need sales agent at respondent establishment had their registration expire on July 8th, 2024, and it had not been renewed as of the date of the examination, which again was July 17th. During this time, the employee had written 1 pre-need sales contract on July 9th, 2024. Respondent replied stating that originally the pre-need contract was written on June 28th and was mailed to the customer. Respondent stated that when the customer signed and dated the contract, it was for July 2nd, 2024. Respondent stated they received the signed contract on July 9th, 2024, and that the employee with the expired registration used the date it had been received and signed it. However, upon review, due to a signature error from the consumer, the contract could not be accepted. A new version of the contract was sent to the consumer on July 10th, 2024, was signed by the consumer on July 11th, 2024, and received by the establishment the same day on July 11th, 2024, by the same employee with the expired registration. Respondent stated that the employee thought their registration expired at the end of the month, and once it was discovered, they worked to correct it. Respondent stated their registration was renewed on July 18th, 2024. Based on the above, we'd recommend a $250 civil penalty, authorized via consent order, and a formal hearing if necessary.
Same verse, second stanza. Any questions for Mr. Bryant?
Yeah, I would just like to ask counsel, how did you come up with the penalty? I see there is several previous disciplinary issues that have come up with this. And I guess I'm like President Stevens, it's just the same song and dance, but nothing seems to be corrected. And again, they had to know their license expired. I'm sorry. I just don't go in agreement that they don't know their license have expired. And I just think maybe 250 is a small penalty. Maybe we ought to look at. So council's guidance.
Sure. So I think two things at play here. One thing that is a little bit of a distinguishing factor is this individual was not a manager. Before, where you kind of you run into problems when, even if you don't do any business, you have an individual who's not a licensed manager operating as manager. We don't have that here, so that's good. That's one violation we've seen a lot today that didn't happen. This individual wrote one pre-need sales contract, and I guess consistent with Mr. Wheeler, your logic from the previous, I guess that would be number 7, $250 per one that was written. I understand what they're saying about, well, when you originally wrote it, it wasn't expired, but I mean, there were a lot of places there where you're doing license activity and you need an active registration. I don't think that's a valid excuse, and admittedly, I did not put weight into that in the recommendation. I think the main thing too, one thing I would, and this is more general because I know when I write these up, I don't practice reading them out loud, but having read them out loud in a row, I know this is a lot of the same violation over and over again. And one thing I would, and not saying that you all are, but more so just in my own brain of realizing the repetition of these same violations, I would just caution on not being, just being consistent throughout, of not being more aggressive, because this is the, I guess, 7th time we've seen this today. This is the first one with this establishment. So just not to go harder just because we've heard it a lot today.
That was one of my questions, is how many of these were the same establishment. I was going back and looking to try to figure out. So looks like there was a very busy inspector on July 17th. So
Let me ask counsel, so I'm okay staying with 250 civil penalty. Can we do a letter of instruction about how you renew your license, and they do expire, and you're supposed to take care of this prior to the expiration date if you continue to wish to write pre-need?
If that's something the board wants to do, I'm happy to author that letter. I think this one is, so I think their explanation was not necessarily, I didn't realize it expired, and more was, I thought it expired at the end of July, not at the beginning of July, which, tomato, tomato on what your excuse might be. But so if the board would also like an accompanying letter with that $250 civil penalty via consent order, I'm more than happy to author that.
I'll make the motion that we do the 250, the via consent order, and a letter of instruction with it.
There's a motion on the floor by Mr. Wheeler for the recommendation of the 250 civil penalty and a letter of instruction.
Second.
A second by Mr. Nash. Mr. Haynes, sorry. I know, it was coming from that direction, guys. Let me restate that. There's a motion by Mr. Wheeler and a second by Mr. Haynes. Any further discussion? All in favor say aye. Any opposed?
Need a comment there, Madam President.
Needed a pause.
Hey, we're getting through this, okay? All in favor, say aye. Aye. Any opposed? Thank you, motion carried.
And that was the last one involving expired registrations, I promise. Last one for today. The next complaint number is...
Mr. Bryant, hold on just a moment,
yes.
please.
I need to recuse myself of.
Okay. Mr. Naylor, if you would exit through the store here, and when we are finished, someone will come and retrieve you.
The next complaint number is complaint number 2024-039861. Complainant alleged unprofessional conduct on behalf of respondent. Specifically, complainant stated that respondent had written an email in a rude and uncourteous tone to colleagues in the funeral industry. Further, the complainant referred to a banquet where they, the complainant, were attempting to set up an area in the banquet event area, and a hotel employee where the banquet was occurring informed the complainant that a table could not be moved without respondent's permission because they, quote, did not want to get cursed out again, end quote. Complainant also stated during the banquet that respondent interrupted the speaker when they began to talk about corporate presence in the funeral industry. Finally, complainant stated that honorees of the banquet had historically received a plaque. However, complainant stated that no plaque was presented to the honoree and claimed that respondent had informed the honoree that they had forgotten to bring the plaque, but that they would have someone ship it to them on June 12, 2024. Complainant stated the plaque did not arrive and they did not receive information about the plaque. Complainant stated the honoree emailed respondent on June 28, 2024 for an update. Complainant alleged respondent emailed back the following day with an, quote, uncaring, unbothered, unprofessional tone, end quote, and instructed the honoree to contact the individual responsible for shipping the plaque. Complainant stated the honoree did not receive the plaque until July 8, 2024. Respondent replied and stated that the reason their tone was considered by complainant as, quote, rough and uncourteous, end quote, is because the honoree did not follow the proper vetting process for the banquet. Respondent stated that because the honoree was being honored, they felt they were able to arrange the banquet in the way they chose in conflict with applicable bylaws. Respondent stated they had to remind the honoree of this on several occasions. Specifically, respondent addressed complainant's complaint of, quote, not having time to set up, end quote, stating that the banquet is done in conjunction with continuing education and that they were required to adhere to the schedule that had been put in place back in January and February. Thus, the timeline could not be adjusted as the honoree and complainant had requested. Regarding the hotel employee, respondent denied speaking to anyone in that matter. Although respondent stated they left specific instructions that no changes or additions were to be made without speaking to them first, this was to avoid incurring additional fees. Next, respondent stated they did not interrupt the speaking, but did say after the speaker sat down after a, quote, rant about corporations, end quote, as a reminder that they did not want to offend any of their members regardless of who they worked for. Finally, regarding the plaque, they stated that the treasurer typically orders, pays for, and brings it with them to the convention. Respondents stated they did not find out until June 10, 2024, that the treasurer had left the plaque and that a member of the convention informed respondent what had happened. Respondents stated they received an email from the honoree inquiring about the plaque. Respondents stated there was no ill will or malice involved, and leaving the plaque was purely an accident. Respondents stated they explained this to the honoree after they accused respondent of having a, quote, personal vendetta, end quote. Respondent advised the honoree to follow up with the treasurer regarding the plaque. Based on the above, the entirety of the complaint alleging unprofessional conduct are industry and personal disputes. Legal would strongly advise the board that this is not the appropriate forum nor appropriate function of the board to settle or discipline for such disputes, and we would recommend closure.
I'll make a motion to accept council's recommendation, and sorry you had to waste time on something like that.
I second.
There's a motion on the floor by Mr. Lee, a second by Mr. Wheeler. I do have a question. Is there something that we could, we can't do anything, but is there another level, maybe the ethics committee of that association? It sounds like it's an association that we could recommend that maybe that complainant be able to go to, or just stay completely out of it?
I would recommend staying completely out of it. That I think if they are, I guess, familiar enough with the association, if they're still, offended and upset by what happened. That if they want to pursue that, that's certainly their prerogative. But I think it's just the board getting involved on this. I think is a dangerous, slippery slope.
This is out of the realm of our responsibility. So there is a motion on the floor by Mr. Lee, a second by Mr. Wheeler. Any further discussion? All in favor, say aye. Aye. Any opposed? Motion carried. If, Mr. Wheeler, if you could bring Mr. Naylor back into the room, appreciate it. Thank you, Mr. Wheeler, and welcome back, Mr. Naylor. Mr. Bryant.
The next complaint is complaint number 2024038341. Complainant, child of the deceased, alleged unprofessional conduct on behalf of respondent funeral director. Specifically, complainant stated that on the day of the gravesite service, the casket did not fit into the vault. Complainant provided that they attempted to lower the casket several times with the family present and purported that they could see the casket shifting. Complainant stated that they and the family walked away to avoid witnessing the issue further. Complainant stated that the cemetery director ultimately assured them that they would make sure the casket got into the vault and sent photographs later showing that it had successfully been placed in the vault. However, complainant stated that in order to get the casket to fit, they had to remove portions of the casket that were purchased and stated that photographs provided showed the lid was slightly raised off the casket. Complainant stated they followed up with the respondent a few days later and were told by respondent that the casket was a few centimeters larger than the vault. Respondent replied, stating that upon arriving at the cemetery for the service, a funeral director identified that the wooden casket appeared to be wider than the vault to be used for interment. Upon this discovery, that funeral director asked the representative from the vault company if the inside dimensions of the vault would accommodate the casket. Respondent stated that prior to removal of the casket from the hearse, the outside of the casket and inside of the vault were measured by the vault representative. Respondent stated that the casket measured about 1.5 to 2 inches less in width than the inside of the vault. Respondent stated once receiving this confirmation, they proceeded with the service. However, respondent stated that once the casket was being lowered into the vault, it became evident that the vault was not going to accommodate the width of the casket. Respondent stated in an effort to find a solution, they consulted with the vault company to determine other vault options that would fit in a standard size grave, and it was confirmed that the current vault was the largest vault capable of fitting inside a standard grave. Immediately following this conversation with the vault rep, the funeral director spoke to the complainant and another family member explaining the situation. Respondent stated they agreed to depart the cemetery at that time, and that during this conversation they were given approval that, if necessary, a portion of the exterior of the casket, specifically the decorative knobs, could be removed. The funeral director stated complainant and the family member would receive confirmation once the casket had been placed in the vault and interment was completed. Respondent provided photos to show that the case of the casket was removed and the casket was successfully lowered into the vault and interment was completed. Respondent stated following the service, they communicated with the complainant to apologize and explain the matter. The next day, respondent also followed up with two daughters of the deceased, listened to their concerns, offered clarity regarding the situation, and apologized again. Respondent stated the call concluded with mutual thanks for the call and that they were under the impression the issue had been resolved. Complainant provided a rebuttal claiming that they had no idea what the issue was until the cemetery owner contacted the vault company, and they purportedly told her that the funeral home had ordered a regular-sized vault for an oversized casket. Complainant contends this was only discovered after the complaint was filed and attached a screenshot of a call from the cemetery owner dated July 10, 2024. Complainant stated they only received a call after the cemetery owner communicated to the funeral home that the family was upset. Complainant further stated that the wood casket and vault were purchased through the funeral home and that although the funeral director purportedly noticed the casket did not fit the vault upon arrival, since the order had been placed through them, they should have been aware of that prior. Complainant also stated that the wood caskets used by the funeral home are cremation caskets that come in regular and oversized dimensions. Complainant stated their father was 5 feet 8 inches and weighed 145 pounds, and that an oversized casket was not required. Complainant refuted respondent's claim that they explained to the family what was happening at the graveside service, stating that they only ensured them that the casket would go into the vault and that they would send follow-up communication once they had done so. Complainant stated that only in a phone call 2 days later, initiated by complainant, was the issue explained to them. Complainant stated they followed up with the cemetery owner who offered to call the vault company and claimed that they reported back that the funeral director had ordered a regular-sized vault for an oversized casket. Complainant claims they received a call from the funeral director where they admitted this error. Complainant provided a photograph of a text exchange where the funeral director offered an apology. Finally, complainant stated that the respondent did not reach out to them to offer an apology and explain the issue, and that the phone number respondent provided in their reply was their sister's number, not theirs. Complainant stated that respondent never called them. Based on the above, there are conflicting reports as to who spoke to whom and when these conversations occurred regarding the casket failing to fit in the provided vault. Respondent contends the funeral director explained this to the family and complainant at the gravesite, and that respondent followed up at a later date and spoke to and apologized to the family again, while complainant contends that they were never contacted and only received an apology after they contacted respondent. What we are certain of is that, according to respondent's reply, quote, the arrangements were made by family member of complainant with respondent. The merchandise was ordered by funeral director per the selections of the funeral service contract, end quote. Ultimately, the casket that was ordered was too large to fit into the vault. The respondent does not deny that they made the funeral arrangements and that a member of their establishment ordered the casket and vault. Based on the above, we'd recommend a $750 civil penalty, authorized via consent order, and a formal hearing if necessary.
Any questions? I have one. So this complaint is filed for the funeral director, not the funeral establishment. Why not the funeral establishment also?
So when we receive complaints, we try to give the complainant the autonomy to file the complaint against who they would like. On rare occasions of it just being entirely inconsistent, very seldom do we shift who the complaint is filed against. My understanding is that this individual, the respondent in this case, was the individual who, let me double check, I don't want to tell you guys the wrong thing. The respondent in this case is the individual who was in the arrangement conference with the complainant and their family. They made the arrangements. I do also know that the individual, based on the information provided, was at the graveside service. And the respondent is also the owner and manager of the establishment. So I know that's a long-winded, maybe not exact answer to your question, but
My question would be that, so I think there's a valid complaint here, but this person was not the person who was the one that made arrangements. And so that the respondent did, you know, they admit that seems like they admit the mistake, but the complainant, it almost seems like they're complaining because they didn't get an apology to me. I hate to be that direct about it, but and we don't know that if the respondent did anything to make it right besides apologize, offer any kind of a refund or anything like that. And it seems like their sibling, I think it says it in there, was the person who made the arrangements, and I'm guessing the person who signed the statement of goods and services and possibly paid for things. So they did attempt to rectify it that way, but I don't know that obviously anybody can file the complaint. That's my only, I don't know if I'm having a question here or not. I just stating what I'm reading from the complaint.
My question to council is, does the respondent deny that they made a mistake by ordering an oversized casket when it shouldn't have been? Do they deny the size of the deceased according to the family member? Because I think all of us know that the family member, what they described, would have went into a regular sized casket. An oversized was not necessary.
there was no denial on that front. One thing that gets tricky with the determination as to whether we are talking about an oversized casket and an undersized vault for that casket is what complainant is saying, relying on that information is hearsay. They spoke to the cemetery manager, and they spoke to a vault rep who told them. So we have two levels of hearsay to work through there. That could be 100% true. It may not be true. I'm sorry, Mr. Nash. I looked at the statement of funeral goods and services, did not see something that specifically denoted the casket is oversized, but I also know that that's not proof positive necessarily one way or another.
So there was no description of the casket on the statement of goods and services?
Essentially, let me pull it up real quick. I remember it being denoted as a wooden casket specifically. So on the statement of funeral goods and services, it only says wood casket is the entirety of the description of the casket itself. And for the outer burial container, it essentially just says outer burial container, parentheses, as selected, and then has the price denotation.
No description at all?
No, not very helpful in that regard. So I tried to call the cemetery manager on a couple of occasions, got voicemail, and of course, voicemail was full and I couldn't leave a message. So I tried to get direct information to get to the bottom of whether that actually occurred. What complainant claims, again, based on hearsay, is that the respondent admitted in a phone call, yes, we ordered an oversized casket for an undersized vault. But of course, that's in a phone call, not in anything else. The text message that they took a screenshot of, the funeral director is, the respondent in this case, is apologetic. Let's see. It's more of a text from the complainant to them about what they should have done, and the funeral director, the respondent here, is apologizing and trying to remedy as best he can.
Does the respondent admit that they removed the hardware off the casket to get the casket to fit into the vault?
Yes, they took photographs of the successful internment into the vault. Let's see. Let's see if I can get an exact quote for you. Quote, as shown, a portion of the base of the casket was removed and the casket was lowered into the vault and the interment was completed. So they had to remove pieces of the casket in order to get it to fit.
I make a motion, we accept council's recommendation.
Motion on the floor by Mr. Wheeler,
Second.
a second by Mr. Haynes. Any discussion?
Just one final question. This 750 civil penalty, is that leaning, sorry, thank you. Is that the $750 penalty, is that more so toward the alleged conduct of the funeral director or the mess up in the ordering or
Leaning toward it is a violation for just the conduct of again, what I've learned in this industry, and I'm by no means an expert, is that when you're doing that, you have to get it right. And kind of if I I know you have to put on your problem solver hat sometimes too when things go wrong, and kind of removing portions of the casket got it done, but you know, it's. I know that's a difficult situation for the family. As far as the communication about offering an apology, to Mr. Nash's point, or not offering an apology, we don't know. There are differing versions about what did happen. Respondent says, the funeral director and I talked to them at the graveside, offered our apologies, kept them in the loop, tried to work with them to get it fixed, and then complainant says, I didn't get a phone call until I filed a complaint. And the truth may be either of those, maybe somewhere in the middle. We don't know, but
just me personally, I have a hard time voting against a penalty on a complaint on something that says there's a lot of conflicting reports in this to me. Not from what you reported, but just from what the funeral director says, what the cemetery person says, and the cemetery person won't respond to you. You know, the vault company, there's a lot of people involved here. That's just, I feel like that, and the respondent, the one thing that no one said is did they do anything to rectify it financially or otherwise? You know, in my opinion, when you're in a cemetery and this is happening, you can just stop. So look, let's stop and let's fix this. You know, and I also, I mean, it just seems like it's a lot of conflicting reports to me. And I don't, that's what bothers me about the whole thing.
no, absolutely. And Mr. Nash, I actually think you and I are on the same page on that, that's why the recommendation and when the consent order goes out, if ultimately that's still what the board decides to stick with, won't mention allegations regarding lack of an apology or failure to communicate or anything like that, because we just have we're in he said, she said, and that gets really hard to suss out. What we do know for certain is that this respondent, this funeral director, was in the arrangement conference. They ordered, for whatever reason, the casket that got there was too big to fit into the vault, and they had to kind of tear pieces of the casket off to get it to fit. That's what we know for sure. So that's where the recommendation comes from.
There's a motion on the floor by Mr. Wheeler, a second by Mr. Haynes. Any other discussion? All in favor, say aye. Aye. Any opposed?
No.
Okay, there is a no vote for Mr. Nash. Motion passed.
And the last one is a represent from the August board meeting. Complaint number 2024029491. This matter was previously presented to the board at its August 13th, 2024 meeting as follows. Complainant stated that they had a pre-planned funeral for her mother that had been purchased in 1987. However, complainant alleged that upon the day of the funeral, Friday, May 3rd, 2024, according to the establishment's website, the decedent was swollen and bloated. Complainant theorized that respondent had left the decedent out of a cooler and in the heat so that decomposition could occur, but provided no strict proof of this claim. Complainant further stated respondent could not find a copy of the decedent's contract, but later did because it was, quote, found in the basement, end quote. The manager of respondent establishment replied on respondent's behalf. The manager stated that after a thorough investigation, there were no findings of abuse of the decedent's remains. Respondent provided that the decedent came into their care on Friday, April 26, 2024 at 4:18 p.m., and the decedent was placed in the refrigerated storage within 10 minutes of her arrival. Respondent stated that the decedent's remains were only removed from refrigerated storage for embalming and preparation purposes. However, respondent did not provide the date, but stated that when the decedent was removed for embalming, they discovered that the remains were showing signs of tissue gas being present. Respondent stated they utilize a specialized embalming fluid specifically for tissue gas. Respondent stated that once the process of tissue gas has begun, it is difficult to stop the damage, and the manager admitted that the decedent did appear bloated due to the presence of tissue gas. The manager stated that they believe their embalmers took the necessary steps to reduce the effects of the tissue gas, but that they are unable to entirely stop the decomposition process. The manager stated that prior to the family's visitation, they explained to the family the bloating issue the decedent was experiencing due to tissue gas, and stated they attempted to explain this to complainant, but that complainant would not speak with them. Respondent further stated regarding being unable to find a copy of the contract that this was false. Respondent stated that complainant was not present during the arrangement conference, so they were unsure how they came to the conclusion it could not be located or was found in the basement. Respondent stated that the contract is stored digitally, and the family service counselor was able to pull the digital and hard copies of the contract during their meeting with the family. At the time, the recommendation was a letter of caution or instruction, and the board asked that it be sent for further investigation. So legal called and spoke to the manager of respondent establishment and obtained the information requested by the board and the embalming report. The decedent passed away on April 26, 2024. Respondent stated they spoke to the family the day after the first call and that the individual who was the next of kin making arrangements was a sister of the complainant. The manager stated they received verbal permission to embalm, but the embalming authorization form provided does not include information for verbal permission. Instead, it has a signature from the sister denoting the authorization for embalming was given on Saturday, April 27th, 2024 at 1:50 p.m. As a reminder, the decedent was received by respondent on Friday, April 26, 2024 at 4:18 p.m. The embalming report stated that prep began on April 29, 2024 at 6:59 a.m. and concluded at 8:42 a.m. Collectively, from the time authorization had been received, approximately 41 hours had passed before embalming began. And based on that, we'd recommend a $500 civil penalty authorized via consent order and a formal hearing if necessary.
Any questions for Mr. Bryant?
I make a motion to approve, Council.
Second.
Sorry, this button thing. Motion to approve.
Motion by Mr. Nash, a second by Mr. Wheeler. Any other discussion?
I would like to thank council for getting that information. That answers a lot of questions
I agree, Mr. Wheeler.
with what you all did, and we appreciate it. I know it takes more time out of what you all need to do, but we appreciate it. It answered all my questions I had from last month.
Absolutely happy to
Thank you,
do it.
Mr. Wheeler. All in favor, say aye.
Aye.
Any opposed? Motion carried. Before we move on to the director's report, I would like to say something, and I'm going to speak on behalf of the board. For those that do have renewals on your establishment or your funeral directors, it is very important to keep up with that, whether it's on your personal calendar or the company program that you might have. But it is, as Mr. Nash and Mr. Wheeler and several of the board have said, it is your professional responsibility to continue to upgrade, get your licenses renewed. And so the state would appreciate it. And thank you, Ms. Bohannon and Mr. Gribble, for all you all do. Thank you. Mr. Gribble, at this time, your director's report, please.
Thank you, Madam President. Good morning. Good morning, board members.
Good morning.
The license review report is a report of licenses that have been administratively approved by the executive director pursuant to board authority for the period of August 3, 2024 through September 6, 2024. Have two establishments and a multitude of individuals there. Closed establishment report for this board meeting. There are two establishments that have reported closing since the last board meeting. Brent Taylor, Paul B. McCarver Funeral Directors in Memphis, and Dixon Funeral Home, the White Bluff Chapel in White Bluff. Disciplinary action report is a report of consent orders that have been administratively accepted and approved by the executive director pursuant to board authority and as reported on the July 2024 regulatory board disciplinary action report. And you have a list of those along with the violation and the civil penalty. As far as complaints, as of September 6th, Ms. Bohannon tells me that there were 34 funeral director and embalmer complaints, 30 establishment complaints for a total of 64 complaints. And, that concludes my report. I'll be glad to answer any questions that you might have.
Are there any questions for Mr. Gribble? I'll entertain a motion to accept his report.
So moved.
Motion by Mr. Wheeler, a second by Mr. Nash. Any other discussion? All in favor, say aye. Any opposed? Okay, motion to accept Mr. Gribble's report. Mr. Gribble, are there anything that we need to address with individuals or establishments on the licensing?
There are no applications for either one.
Okay, thank you. So if you see in your report, For 2025, there are board meetings that have been established. As you all know, we do meet on the second Tuesday of each month, and occasionally those meetings have been canceled for one reason or another. But at this time, I do need to have a motion to approve those board meeting dates for 2025.
So move.
Motion by Mr. Wheeler. Second by Mr. Lee. Any discussion? All in favor, say aye. Aye. Any opposed? Okay. Thank you. At this time, Ms. Bohannon, was there anyone that signed up for comments, public comment?
No, Madam President.
Thank you. And if anyone in the audience has any comments that they would like to make at this time, now's a good time to do that. Okay, all right. Thank you. And again, Mr. Batson, thank you for representing funeral directors and across the state. Our next meeting will be October 8th. Does anybody have any response on that one?
That's what I was waiting on, and how
Okay.
far we were going.
Thank you.
We're kind of new at this, Mr. Gribble, but Ms. Stevens and Mr. Nash, myself, we've narrowed down a place for the past president's luncheon. We're waiting on a confirmation phone call back. It'll be after the October 8th meeting is what we're looking at. So would it be best for you guys, for us to maybe email your office to send out an email to the past?
Whomever, whichever one is coordinating. Sorry, I didn't turn my mic on. If you will, Mr. Lee, when you get that confirmation, if you'll just send it to me and Ms. Bohannon, we'll take care of getting in touch with the 3 board members that went off last year. We have communicated to them and told them tentatively the board has been looking at the October board meeting.
Yes, sir.
Nothing definite, but once you get to place, if you'll let me know, we'll communicate that to them and make sure and we'll also take care of getting a plaque for them.
All right.
That the president presents to them after that luncheon.
So the question was asked, approximately how many people attend that? I know there's inspectors and state.
We'll work with Mr. Lee and
Sure.
get that number.
Thank you.
To
Good.
get it to where you can, because I know you have to guarantee it usually. So we'll work with you on that.
Is there any other business that needs to be brought before the board?
Ms.
Again,
Stevens,
yes.
did you want to mention if someone was interested in?
Oh, thank you. Thank you. Mr. Gribble and I had a discussion. It's that time of year that, believe it or not, we're closing in on soon to be the last quarter of the year. That's hard for me to say, but at that time, we do have a vice president at this time, but we would need to elect a new vice president, because hopefully Mr. Lee will move into this position as president, as his acknowledgement last year of wanting to moving into a new position. I'd just like to plant the seed for anyone here that has an interest in becoming part of the officer role with the board. And I am looking forward to the January meeting and moving on. And at that time, it is my understanding that until a Middle Tennessee representative is named, that we continue this board. But if anyone does have an interest in moving into a leadership role, if you would let Mr. Gribble know or myself, we would appreciate it. We're just planting a seed at this meeting.
Let me suggest something.
Sure.
Or clarify something. Typically, what the board does in November or December, one of those meetings, they will elect a president, a vice president, and the board would appoint a continuing education liaison. I'm sure Mr. Nadler probably doesn't want to do any electioneering for that, to retain that another year. Those people get contacted quite a bit, and we do appreciate everyone's role in what they do. But then when you make that election, whomever you elect, then those people take the office January the 1st. And like Ms. Stevens said, she will stay on the board until there's a replacement appointed by the governor for her board sometime, for her position. Sometimes that comes quickly, sometimes it doesn't. That's entirely up to the governor's office as to when they make that appointment and whomever that person is. But I think what the board has historically done is maybe at this meeting or at the next meeting, whatever you determine, Ms. Stevens, it's entirely up to you and the board. But so that there's an openness among the board members that those people desiring to be president or vice president or continuing education liaison, they make that known maybe at this meeting, or if not at this meeting, at the October meeting.
I would suggest the October meeting. It is something to really think very carefully about, so. But thank you, Mr. Gribble. Anything else?
Real quick, I'd like to again thank the board for the opportunity for me going to Rhode Island. I think Mr. Gribble will be there. I did get my airfare booked. At the deadline, I was a little behind, but I just again want to thank the board for the opportunity. I'm looking forward to it, and hopefully we'll have a little report for you next board meeting.
We appreciate you and Mr. Gribble taking care of that. Anything else? Have a motion to adjourn. Do I have a second? I'm not going to ask for discussion. All in favor, say aye. Thank you. Thanks, Ms. Bohannon, Mr. Gribble, and Mr. Bryant.